So we'll continue with the next chapter of the Indian Partnership Act. As you all know, my name is Dr. G. Mallikarjun. So now we'll talk about Chapter 5 of the Indian Partnership Act, which contains sections from 31 to 38. And this deals with incoming and outgoing partners. So it talks about the most important aspects here are what are the modes of exit of partners and entry of partners. Then retirement or expulsion of partner and the consequences of something which are very, very important. Then the chapter has sections 31, which talks about introduction of a partner with the consent of all, and minor's introduction we've already seen in section 30. Then sections 32, 33, and 34 deal with three modes of going out of partners. One is by retirement, second is by expulsion, third is by insolvency. Section 35 talks about the death of the partner and liability of the estate of deceased partner. Then section 36 and 37 talk about the right of outgoing partner to carry on competing business, and in certain cases to the share of subsequent profits even after they go out. Section 38 talks about a specific case relating to continuing guarantee, where there is a change in the constitution of the firm. It is the continuing guarantee will be deemed revoked unless there is any other contract to the contrary. So the incoming and outgoing partner, the nature of changes could be coming in of partner through introduction. The other mode of coming in of partner is in case of a minor where he chooses by public notice to become a partner. Then second is outgoing of partners. The modes could be retirement, expulsion, insolvency, or death. Then rights of outgoing partner to carry on competing business, then to share of subsequent profits, then revocation of continuing guarantee by change of the firm. The first section 31 talks about introduction of a partner. Subject to a contract between partners and to the provisions of section 30, where minor is admitted to the partnership benefits, no person shall be introduced as a partner into the firm without the consent of all the existing partners. So the default option is all the partners should agree for someone to be introduced. And same is the case with a minor, that all the partners should agree for admitting a minor for benefits of the partnership. However, you could have a contract where a person or a certain group of persons could be given that power, or it could be some matter which could be decided by a majority of the partners. So that's the first provision. Then subject to provisions of section 30, a partner who is introduced as a partner into the firm does not thereby become liable for any act of the firm done before he becomes a partner. So the liability subject to the provisions of section 30 is prospective. Why section 30 is coming up here? Because under section 30, when someone is admitted into partnership based on the consent and subsequently he attains majority, within 6 months of his attaining majority, within 6 months of getting to know that he has been admitted to the benefits of the partnership, he has to by public notice indicate his intention of whether he will continue or he will opt out. If he continues in the partnership, his estate will always be having a financial liability, but there will not be personal liability on the minor as long as he is a minor. But imagine he becomes a major, and within the period of 6 months of getting to know of admission or attaining majority, whichever is later, if he chooses to be a partner, then the financial liability of his part will continue, but personal liability from the period that he has been admitted will continue. So this is in case of a minor, the liability will start retrospectively, though his admission as a full-time partner will happen on the day he gives a public notice of his intention. So from that point of view, so excluding this minor, if a new person comes in, it is natural to protect him that he should not be made liable for something which has happened before he becomes a partner. However, there could be a contract which could have other mechanisms of introduction. So basically, all partners to consent for admission of a new partner being a relation of trust and confidence. It's not just anybody who comes together to have a partnership. Unless I am going to have the kind of comfort of having these people together because of various aspects like joint and several liability, etc., unlimited liability, I would want people whom I am comfortable with only to be in a partnership firm. Then contract could provide for other mechanisms of introduction. So where nomination by one or more partners is a mechanism which can be provided by contract, but if someone does not accept, then the court cannot say that you should accept him as a partner, because it's a matter of choice of the partners. So there could be a violation of or a breach of a contract. For that purpose, they could claim damages, but the court cannot say that you will have to accept this person as a partner. Then nomination by partner by will for a person to succeed. This has been held to be not enforceable, because the person who is being nominated was not a party to the agreement. And the same concept that is there, like they have to know about the person and be satisfied about the person coming in. So it cannot be an inherited kind of a arrangement for bringing in new partner. Then clause in the deed providing right of a partner to bring son as a partner on attaining majority. This was held to be enforceable, because it is presumed that he will bring some continuity. Then other partners in this particular case, where the contract provides for this, cannot refuse. This was held in the case of Band versus Reed. Then what is the liability of the new partner? So no liability for any act of the firm done before he enters the firm. Liability commences from the date of admission. However, this also can be modified. So the new partner can admit liability for the debts as on the date of his joining. And this arrangement is basically between the partners and the third parties. But if the third parties have to hold the new partner liable, then the new partner liable should agree for the liability. Then the third parties or the creditors, as far as this firm is concerned, should be made aware of the arrangement. And after getting to know of the arrangement, they should be acquiescing in it, or they should be either expressly or impliedly agreeing to deal with the partnership. So basically, it will be treated as employed if they continue dealing with the firm. It means that there is no objection that is there for this arrangement. In this, let us see a few cases. In BM Devaya versus Canara Bank, the new partner in the reconstituted firm agreed for pre-existing liability and started clearing the dues. Though the new partnership deed did not provide for a partner assuming liability for the past debts. Then this new partner coming in was informed to the banker, and the banker continued to deal with the firm as if he was dealing with the firm before reconstitution. Then when the banker wanted to hold the new partner liable, it was indicated in an action by the banker that the new partner was liable, irrespective of whether the deed is reflecting the fact that he is assuming the new partner has assumed the liability for the existing liabilities or not, because of two things. One, by conduct and other documents, it indicated that the new partner accepted the pre-existing liability and paid those dues as well. Then second thing, the bank came to know about this and continued to deal with the reconstituted firm and accepted the new partner. Then in case of British Home Association and Company versus Patterson, this is a different thing where the bank did not recognize the new person coming in, but was dealing with the earlier person only. So the reconstituted firm or the new person entering was not taken cognizance of by the bank. But subsequently, when there is any problem, they were held that since you didn't recognize and you were dealing with the person, now you can't go back and say that I will bring him into liability. So here in this particular case, a solicitor A appointed by the company for a mortgage transaction inducted another person B into the partnership. And as usual, he issued a notice to inform the company of this reconstituted nature of the firm. The company did not pay attention to the notice. Then it corresponded and made payments and issued checks payable to A's order only, not for the firm. And it received acknowledgement only from the solicitor A, whom they were dealing with. Then now solicitor went ahead and misappropriated the amount. Now the company goes back and says that now I want to sue the new partner. Then it was held that the new partner was not liable because the company did not acknowledge the reconstituted firm and the new partner through its dealing. It was only dealing with the solicitor directly, more like an individual rather than as a firm. Then the second mechanism, the first mode of going out of a partner is what is called by retirement of the partner. So this is section 32. It's a very important section because the provisions relating to section 32 will apply for 33 and 34, and some parts of it will not apply in case of death or insolvency. So what are the modes in which a partner can retire? Subsection 1 says a partner may retire with the consent of all the other partners or in accordance with the express agreement between the partners. Agreement between the partners, or where the partnership is at will by giving a notice in writing to all the other partners of his intention to retire. A retiring partner may be discharged from any liability to a third party. A retiring partner may be discharged from any liability to any third party for acts of the firm done before his retirement by an agreement made by him with such third party and the partners of the reconstituted firm. And such an agreement may be implied by the course of dealing between such third party and the reconstituted firm after he had knowledge of the retirement. So the first one talks about the modes of retirement. The second one talks about the discharge of liability of any third party for acts done before his retirement. Then subsection 3 talks about liability for acts done after his retirement. What are the three modes of retirement of a partner? First, by consent of all the partners. 2, by an agreement. If there is already a deed in the agreement, or subsequently a new agreement is drawn up, a separate agreement for this purpose of retirement, if it is included, then according to that particular clause of the deed or the separate agreement, accordingly he can opt for retirement. And third, where the partnership is not having any tenure or the tenure is over and it is still continuing to run or do business, then it will be a partnership at will. So in this particular case, a mere notice is sufficient for a partner to retire. So here, in a particular case of Vishnu Prasad versus Chandrika Prasad Agarwal and others, the partnership had a clause that a partner could dissociate from the firm after serving 1 month's notice to remaining partners. So they indicated that this is a partnership at will. The court said that this is not a partnership at will because there is a termination clause and there is a clause which provides for a mode of retirement. And the partner can retire by giving a notice as per the terms of the agreement. So it is not by the operation of a notice and a partnership of will, but an operation of a clause of the agreement in accordance with which the retirement will happen. So in this particular case, it is not necessary that the firm should be dissolved. So retirement here is more by an agreement as per the deed rather than by retirement after a partnership at will, which could result in the dissolution of the firm. Then notice has to be in writing and signed by partners and served upon all the partners. However, in certain cases, the court has held that serving to all partners in writing may not be necessary. So first case, they indicated that if it is served on the partner who is habitually acting for the firm, that is sufficient, and you serve a notice to the firm also. These two will be sufficient. You don't need to go and serve it for individual persons because by practice you have made that anything that you give to this person, it is deemed to be that you have told all the partners. So that operation will continue. This was in the case of Ushar Gopi Ratnam versus P.S. Ranganathan. Then second thing, if it is served on some partners in writing and others if they are informed of phone, one way or the other, if he is informed, then or notice is given to them, that is sufficient. So now when will the retirement be operational? Because liability ceasing will have an impact from that particular day. Then for where there is a date indicated in the notice, from the date indicated in the notice, it will be the person will be deemed to be retired. Then second, where there is no date in the notice, the date of service of the notice will be treated as a date of retirement of the partner. Then the second subsection talks about the liability. So a retired partner is liable to third parties for acts done before his retirement and after his retirement. So for acts done before his retirement, naturally being a partner in the firm, he is liable generally. Then for acts done, he is not liable to partners, but is liable to a third party because he could have an agreement with the partners of the reconstituted firm saying that he will not be liable as far as the partners are concerned. So the partners could release him from the existing liabilities. But for the third party, he would still be liable. Then unless notice is issued, then he is not liable for third parties also in case there is a modification of the new firm's agreement with a replaced one in a reconstituted firm. And three aspects have to be fulfilled necessarily for a partner who is retiring to be held not liable. What are those three aspects? First, agreement between the retiring partner and the partners of the reconstituted firm to do away. That is the one which is already there, where they have agreed to release him from the debt. That should be there. Then second thing, intimation to the third party of the retirement of the partner and release of him by agreement, and the new arrangement of clearing debts and liabilities by the reconstituted firm. So the third party should be informed about the fact that this person is retiring, and then whatever debts are there, we have released him from liability based on an agreement that we have entered into with him. And this will be the mechanism by which we are going to pay up the dues which we owe to third party, to you, who is a third party. That has to be, that intimation is necessary. Then apart from this intimation, mere intimation is not sufficient. There has to be a consent from the third party to the arrangement. And how could this consent be given? By an express acknowledgement or a consent that they convey that we are okay with it, or implied, that is they continue to deal with the firm without any change, as if that kind of a continuance will make the acceptance to be implied. So all the three elements are necessary for release of liability of a third party for acts done before retirement. Mere notice is not sufficient. Then, notwithstanding, the third provision talks about done the holding out related aspects. So, notwithstanding the retirement of a partner from a firm, he and the partners continue to be liable as partners to third parties for any act done by any of them, which would have been an act of the firm if done before their retirement, until a public notice is given of the retirement, provided that the retired partner is not liable to any third party who deals with the firm without knowing that he was a partner. So here, if any partner continues to do any act to the firm, if he would have been liable before retirement, and if he continues to do those acts, then he will be liable for those acts vis-a-vis third party even after retirement. How can he escape this liability? How is this happening? Because he is holding out and he is not informing them that he is now no more associated with the partner. How does he inform him that he is no more associated with the partnership firm? He has to give a public notice. What are the requirements relating to public notice as provided for in section 72 of the Indian Partnership Act? So here there is a distinction in the public notice between a registered firm and an unregistered firm. In case of a registered firm, you have to give a notice to the registrar of the change. Then you have to make a public a notice in the official gazette. You will have to issue a notice in the official gazette. And the third thing is, in the place where the place of business of the firm, there an advertisement has to be issued. A notice has to be published in a local newspaper. These three modes are supposed to be there for giving a public notice in case of a registered firm. In case of an unregistered firm, because its details are not there with the registrar, you don't need to give the intimation to the registrar. But the other two modes of making a notice in the official gazette and publishing a notice in the newspaper within the area, so those requirements continue to be applicable. So only when these two things are done, he will not be liable for any act of the firm vis-a-vis third parties. The other area where he will not be liable is if the firm does not know that this fellow is partner, then he is dealing with him as if he is an individual. So now Subsequently, it cannot go and say that now I later find out that he was a partner. Then he cannot say that I will hold him liable because he was a partner. You didn't know about it when you were acting with him, interacting with him. So subsequently knowledge, you can't hold him liable. And in that particular case, a public notice is not necessary as well. Then who should give the notice? It can be given either by the retired partner or by any partner of the reconstituted firm. By the retired partner because he doesn't want to be liable for holding out under section 28. For an existing partner of the reconstituted firm, they should not be treated that now you have agreed to it, so you are stopped from now denying that he is not a member of the partnership firm. So that principle of estoppel will be the reason why the partner of the reconstituted firm is supposed to be giving a notice, and principle of holding out will be the reason why outgoing partner is supposed to give a notice. So now let us see these elements. For acts done after retirement, liable generally, except in case of torts committed or acts of insolvency committed by the continuing partners. However, because the world does not know that he is not a partner of the firm anymore. So how will the world get to know about it, and when will the liability cease? When public notice according to section 72 is given of the fact of retirement of the partner. So by the retiring partner because of holding out of the partner, and by the partners continuing because of estoppel against the firm. So now he goes and deals with the third parties. The partnership does not want itself to be put to trouble because of whatever he is doing. So in that case, the partnership will issue a notice. Then second thing, this institution is not doing well. Now he may be subject to liability and he wants to keep the other third parties informed, in which case he will go, the retiring partner will go and give a notice. So that is generally why the importance of giving public notice. Whoever is interested or whoever is worried about the liability that could be coming out, they will be the ones who will be going and giving a notice. Then he will not be liable if the third party does not know the retiring partner to be a partner of the firm. So some of the cases, so in this particular case, no liability of retired partner for acknowledgement of debt by continuing partners to a party who knew of the fact of retirement. So he knew about the fact of retirement, then he is acknowledged debt, the debt has been acknowledged by existing partners. So now he cannot hold the retiring partner liable for the dues or for the debt. Then no liability to third party for a partner not known to the third party to a partner, whether the notice of retirement is given or not. So that's what I told. Notice of retirement is not a requirement where the other person does not have knowledge that he is a partner. Only if he has a knowledge of him being a partner will he know that the mutual agency principle will apply and the firm will be liable, and he will also be liable for the acts that he does. But if the third party is not aware that he is a partner, then no liability accrues on the person and no liability insofar as the firm is concerned. So where there is a bill of exchange which was incurred by continuing partners, asking for the money to be paid in respect of this dishonored bill of exchange. After 3 years of retirement, it was held that the retired partner is not liable. This was a case of Glorious Plastics versus Luggate Enterprises. Then where there is a check that was issued by the continuing partnership and the check bounced, for that dishonor can the retired partner be held liable? It was said that it is not, that he is not liable. Then we have seen in the earlier case also where there is a dishonor of check. The person who is causing this dishonor or who is maintaining the account, he will be liable for any problem that is going to arise. Then this particular case relating to dishonored partnership check is Meenakshi Satish versus Southern Petrochemical Industries Corporation Limited. Then the next part of going out of a partner is through expulsion. So the previous one was retirement, now it is expulsion. So section 33 deals with it. So subsection 1 says a partner may not be expelled from a firm by any majority of the partners, save in exercise of good faith, of powers conferred by contract between the partners. So here the requirements are that there has to be a clause, then it cannot be a majority decision unless it is provided for, and even if it is a majority decision and it is supposed to be conferred in the contract, the powers have to be exercised in good faith. Otherwise, you cannot expel a partner. The provisions of subsection 2, 3, and 4 of section 32 shall apply to an expelled partner as if he were a retired partner. So those liability of acts done before the expulsion, liability for acts done after expulsion, and public notice requirement by expelled partners or continuing partners is applicable even in case of an expulsion, outgoing of a partner by expulsion. So what are the requirements that are there for expulsion? The agreement should have a provision granting the power of expulsion to the partners. And that power has to be exercised in accordance with the grounds provided in the agreement. On what grounds? Say dishonesty, he is creating a problem, he is a nuisance, he is pilfering money. So you could indicate what are the various types of things, or he has been held liable for any misconduct, he has been penalized by enforcement authorities. You could build whatever you want to build so that the trust, mutual trust and confidence and the good faith between the partners, anything that is done which shakes that, there can be a power which can be provided in the agreement that on that ground I can expel a partner. So, but once that ground is established, that power of expulsion should not be used. It has to be used in good faith. And wherever there are provisions in the contract in relation to expulsion of the partner and the conditions for it, the court will not give a very wide interpretation so that a partner can be expelled. It will give a very narrow and strict interpretation to this clause so that the partnership will be allowed to be continued and the person should not be deprived of being a participant in a partnership firm. So this was indicated in Shivraj Reddy and Brothers versus S. Raghurao Reddy. So for expulsion, if expulsion is provided for in the agreement and done for proper purposes and in good faith, a partner can be expelled. But does he have to be given principles of natural justice? Have they to be followed in this particular case of expulsion? It is where there is an express contract and it is in accordance with that contract and the clause and in exercise of good faith, then the court held in Green versus Hobel that no notice is also required for this expulsion. However, in any case, it is good to give a notice before you expel someone so as to avoid the problems or interference with the matter by courts. Then there is another case of Blissett versus Daniel. So in this particular case, there were a set of partners. One of the partners indicated that he wanted to appoint the partner's son as co-manager. So then one of the partners said that nothing doing, I don't agree to this. So then now what the father who's affected, he goes about telling all the partners that this fellow is not appropriate. So we will all, they came together, signed, and then he served a notice of expulsion to the objecting partner, and then finally they expelled him. So the validity of the expulsion was contested and the expelled partner went to the court. And the court said that though the decision of expulsion, etc., there is a majority power. It is intended for ordinary matters. We have seen in what is it, chapter 3, relate between partners, whatever is the relationship between partners, we talked about this majority powers, etc. So this majority power, which is there for ordinary matters, cannot be exercised for expulsion, and if they are exercised for expulsion, they should be exercised in good faith and they should not be abused. In this particular case, it is an abuse because of some objection being raised by the partner. So the ganging up of all the other majority partners and then throwing him away is not something in good faith. So that expulsion was set aside by the court. Then expulsion was held to be justified where the partner was affecting the firm's business. So where he was sending a notice to the bank saying that you don't honor checks, those kind of activities which are hindering the firm's continuance of business was being done by a partner. Now, the partnership went and gave him an expulsion before he was expelled. Then finally, when he failed to give reasons, even after the opportunity was given, then he was expelled. So when this was contested, it was held that the expulsion was justified. This was in Ganesh Chandra versus Gopal Chandra case. Then a partner who was in Draper's business, he was held convicted for ticketless travel. So, because there was a breach of duty of being an honest man, because this man is a dishonest person who is engaging in ticketless travel. So, when the firm decided to expel him, so it was held that it is appropriate. We have seen in the relation to partners that this relationship is a relationship of absolute good faith, trust. So, the fact that he is not complying with the regulatory requirement of purchasing a ticket and traveling, that itself gives the kind of person indication about the kind of person that he is. So, if he is expelled for that reason, the courts felt that there is nothing wrong in it. This was in case of Carmichael versus Evans. So, in another case, when two people were guilty of misconduct, then the third person came ahead and then said that I am expelling these two. Then they said that the power of majority, the power is for the majority against the minority, but not for the minority against the majority. So in this particular case, it was held that this kind of expulsion is not appropriate. The only option that could have been exercised at that time was to go and ask for dissolution of the firm, because anyhow the parties are guilty of misconduct and there is no point in continuation. So instead of expulsion, go for dissolution. Then in cases where the expulsion was held to be not proper, expulsion will have no effect and the partner has to be reinstated. So because of this publicity, if there is any malicious publicity done or if any harm is caused to the partner in the period between him being expelled and being reinstated, in that case, the partner will be eligible for damages. So where the expulsion is not proper, he could be reinstated, and if some malicious publicity, harm or damage has been caused, he will be compensated for it by payment of damages. So the position of expelled partner is same insofar as the retired partner is concerned, insofar as discharge liability for prior acts are concerned. Then continuance of liability to third parties for acts of firm. So those three requirements that the partners should agree to it. There has to be an intimation of how the liabilities are going to be settled. And third, that the third party also should agree for such an arrangement. So only if these three things are there, there will be liability. They will escape liability. But in the other case, they also have to give public notice, either the expelled partner or the continuing partners. So the other event of a partner going out is what is insolvency. Insolvency is referred to as civil death. So where a partner is adjudged insolvent, he ceases to be a partner on the date of order of adjudication, whether or not the firm is dissolved. So if insolvency in the contract indicates that the firm will be dissolved, then the firm will also be dissolved. The day one of the partners is adjudicated to be an insolvent by a competent court, from that date of order, he will cease to be a partner. Where under a contract between partners, the firm is not dissolved on adjudication of partner as insolvent, the estate of the partner so adjudicated is not liable for any act of the firm, and the firm is not liable for any act of the insolvent done after the date of the order of adjudication that is made. So in this particular case, the liability will cease from the date of order of adjudication. Liability of the estate of the partner for acts of the firm, or for the firm for any act of the insolvent. Then where under a contract between the party, the firm is not dissolved by the death of the partner, the estate of the deceased partner is not liable for any act of the firm done after his death. So first event is insolvency, which is civil death. The second provision 34 is relating to insolvency. 35 is in relation to death. So where the person dies, the estate of the deceased partner will not be liable for any act of the firm done after his death. Similarly, in case of an insolvent person, the events where partners cease to be partners immediately from the date of death, from the date of insolvency, is in case of death and insolvency. The firm can cease to exist or continue after insolvency or death, depending upon how the contract or the agreement is drawn upon. Then liability of the firm to third parties for acts of firm after death or insolvency. So one, the estate of the insolvent or the estate of the deceased partner is not liable. This is basically intended to protect the estate of the deceased person and also the insolvent, so that whatever recoveries can be made from the existing liabilities. No future liabilities should accrue for these two categories of persons. And because of the fact that the persons are no more, either civil debt or real debt, no public notice in respect of this is necessary for them to cease to be held liable. Then goods ordered when the partner was alive, but they were delivered after death. So in this particular case, it was held that the estate of the deceased is not liable for action on price of goods delivered after the death. So liability will cease for those which have happened after the person has died. Then there are two aspects which talk about rights of outgoing partner. So one is in terms of carrying on competing business. So first, an outgoing partner may carry on a business competing with that of the firm, and he may advertise such business. So nothing wrong about him doing the same business or making an advertisement. But subject to a contract to the contrary, he may not use the firm name, represent himself as carrying on the business of the firm, or solicit the custom of persons who were dealing with the firm before he ceased to be a partner. So there's nothing wrong in him doing the business, but he should not be doing, unless there is a contract to the contrary, he should not be doing it using the firm's name or representing himself to be a partner in the firm, or using the customers of the firm. So any agreement in trade, so you can stop him from doing similar business. So for that purpose, an agreement could be entered into, and a partner may make an agreement with his partners that on ceasing to be a partner, he will not carry on any business similar to that of the firm within a specified period or within specified local limits. And notwithstanding anything contained in Section 27 of the Indian Contract Act, such an agreement shall be valid if the restrictions imposed are reasonable. So this is in case of agreements in, so he can do competing business, but there could be an agreement restraining him from doing competing business in a particular area or within for a particular period of time. And if it is reasonable, then that is valid. Notwithstanding Section 27, which says agreements in restraint of trade are void. So an outgoing partner, the provisions of this Section 36 are aimed to ensure that he has the, just because he is out of the partnership, he will not be in a position to do what he has been doing for long. But there is an element of balancing that is supposed to be done through this provision. What are the two elements that are intended to be balanced? One, the right to do business of the outgoing partner. Then second, the interests and the goodwill of the firm from harm or injury caused by the person who is going out. So using the firm name, then taking those customers, etc. This is not something which is an appropriate manner. So the protections for a continuing firm are: the outgoing partner should not use the firm's name, should not hold out as a partner, or break away or use the firm's customers. So he is restraining from, so it was held that he can't draw a list of the firm's customers or solicit customers of the firm before he was going there, unless there is an express agreement for that purpose. So automatically he will take all the customers along with it. That should not be happening. The second thing to prevent that from happening is the partners can have an agreement with the outgoing partner saying that he will not do the same business for a specified period or within the local limits. And if these restrictions imposed are reasonable, then the agreement will be treated to be valid. Though Section 27 of the Indian Contract Act says that such agreements are not valid. So let us see what are the examples that are there in terms of which cases the court held that agreement in restraint of trade is reasonable and can be enforced against the outgoing partner. So in this particular case of Espley versus Williams, a retired partner in an estate agency was asked not to practice by himself or in any other manner within 2 miles of the firm's premises for 2 years. So to protect that turf and protect the firm's interest and their customers and clientele. The outgoing partner was asked to not operate either singly or through any other firm or in any other manner within 2 miles of the real estate firm's premises and for 2 years period. This was held to be reasonable and enforceable. In case of Whitwell versus Bradford, the retired partnership was a firm of doctors, and while he was going out, the doctor was, the clause indicated that he should not be doing medical practice within 10 miles for 21 years. And though 21 years may be seeming too long, since the restriction is only within 10 miles, the court felt that this is a reasonable agreement in restraint of trade. Then the rights, 37, rights of the outgoing partner for profit. So the first is in terms of restraint of trade and continuance of doing business, etc. The second is in terms of profit. So the moment an outgoing partner goes out, so either his share is given and paid off, or second thing is his share and the goodwill that is there is purchased by the existing partner and he will be paid off by the existing partner or the firm, and then he will go. But in case where a member of the firm has died or otherwise ceased to be a partner, and the surviving or continuing partners carry on the business of the firm with the property of the firm without any final settlement of accounts as between them and the outgoing partner or his estate, then in the absence of a contract to the contrary, the outgoing partner or his estate is entitled at the option of himself or his representatives to such share of the profits made, since he ceased to be a partner, as may be attributable to the use of his share of the property of the firm, or interest at the rate of 6% per annum on the amount of his share in the property of the firm. So let us now examine these items in a detail, but there is a proviso to this also, which says, provided that whereby a contract between the partner, an option is given to surviving or continuing partners to purchase the interest of the deceased or outgoing partner, and that option is duly exercised and it is purchased. The estate of the deceased partner or the outgoing partner or his estate, as the case may be, is not entitled to any further or other share of profits. However, if any partner assuming to act in exercise of the option does not, in all material aspects, comply with the terms of purchase of this, then he is liable to account under the foregoing provisions of this section. So here, what are the aspects on the person dying or going out? The firm could carry on the business of the firm with the property of the firm, or it could be dissolved. But if it is carrying on the business, then automatically when someone goes or someone dies, there has to be a final settlement between the existing members of the partnership firm and the outgoing firm. That does not happen. Then if that does not happen, automatically the outgoing partner or his entire estate is entitled to be one, because his property has not been severed and paid back to him, he is entitled to a share of profits, even after he ceased to be a partner or after the person has died, a partner has died, which is attributable to the share of the firm's property that has been used. So his share should have been taken out and paid out to him, but you have not done, but you are using it for the partner's business, so he has to be paid share. The second thing is you could capitalize it and pay an interest at the rate of 6% per annum on the share of the outgoing partner in the firm. So this is the requirement. You could have a contract to the contrary. Okay. The second thing is where he is purchased, the share of the outgoing partner is purchased by surviving or continuing partners. Then the estate of the deceased partner or the outgoing partner is not entitled. Now, since he has sold it for a consideration, that consideration is sufficient. You don't have to pay him anything in the form of any future shares of the profits or any interest at the rate of 6% as was there earlier. But in which case it becomes payable is they have agreed to purchase and say that I am going to pay you the consideration either in one installment, 2 installments, but that has not been done. Then again, I will be eligible to get whatever dues are there in accordance with this section. So that's what is section 37 talking about. what are the consequences of a partnership firm where it continues even after the outgoing partner or the deceased or the partner dies or goes out of the partnership firm. So the rights of the outgoing partner is first to have settlement of the accounts. And once the settlement is done, to get this share of the property. So if the account is not settled for whatever reason and the partnership continues to be going on, there are two options that he can choose. One is allow the use of his share by firm, in which case he has to be paid shares of profits for the use of the partner's share of the firm's property, or he could be paid interest at the rate of 6% per annum on his share of the firm's property. The other thing he can do is sell his share to continuing or surviving partners. So in which case, if the sale is done based on whatever terms, then he is not entitled for any further profits or interest. But if the buying partner does not comply with the conditions of this transfer, with the sale of the share, then he is liable to account for profits and interest. So these are the consequences of the what are the rights that are available for an outgoing partner. Then the other aspect is that where there is a continuing guarantee. So where there is a constitution, the firm's constitution changes once any person goes out or any person dies. So now in that scenario, what will be the position in respect of a continuing guarantee? So here the section 38 talks about that. It says a continuing guarantee given to a firm or to a third party in respect of transactions of a firm in the absence of agreement to the contrary is revoked as to future transactions from the date of any change in the constitution of the firm. So here, continuing guarantee is provided for in section 129 of the Indian Contract Act. Basically, something like a cash credit account or an overdraft account where there are series of transactions coming in and going out, etc. So the guarantee which tends to extend to a series of transactions is a continuing guarantee. So once the guarantee is given, it can be revoked in two manners as per section 130 by giving a notice to the creditor saying that now onwards I am not going to be liable. Then second thing is if the surety dies, then automatically the guarantee will be revoked. But in case of a firm, what happens is it could continue after the reconstitution of the firm, in which case, what will be the position in respect of the guarantee? So the general rule is that when the constitution is changed, automatically from the date of change of constitution, the continuing guarantee will cease to operate. However, you could have a term to the contrary or an agreement to the contrary saying that it will continue to be operational. So this is another instance of accounting of this where the rule in Clayton's rule, principle in Clayton's rule or rule in Clayton's case will be applicable. So this is something which is indicated in a banking law class. So what is the rule that when there is a firm and there is a guarantee, then there are a set of debits and credits happening. So one of the partners dies or the firm gets reconstituted. So now subsequently credits that are happening there into the account will tend to bring down the liability of the partner who is deceased or who has gone out, unless you are going to stop the account and then have a new account and have the credits and debits go into that particular account. So the general principle in Clayton's case or the rule is first in, first out. So where there is a first debit and the first credit goes, if there is no express intention indicated, the first credit will go for clearing up the first debit. So in this particular case, if the guarantee is there and there is a debit transaction that is happening, the constitution of the firm has changed. So subsequently another credit comes, then the debit gets reduced. So the total liability of the existing partners before reconstitution will get affected because of operation of the rule in Clayton's case. So that's the reason why you need to have tell the bank also that the constitution has changed, and then you say that now henceforth whatever transactions we are going to have, you put it in a separate account and freeze this account so that there settlement of the accounts in respect to the partnership firm and paying out for that outgoing partner has to be done. So that mechanism needs to be ensured. And why is this provision necessary? This is necessary for protection of outgoing parties' interest to not make him liable as a surety for transaction after he goes out of the firm or after he dies. So otherwise, subsequently, there is another debit, then his liability will keep swelling. So that should not be possible, because in case of death, what is it, in case of a retirement, etc., the liability will be up to the date that he has been in the partnership firm. So that is as far as the provision relating to revocation of continuing guarantee. So these are the provisions that are relating to incoming and outgoing partners, where you have incoming through introduction, minor being introduced, which we saw in section 30, then outgoing in the form of death, insolvency, then expulsion and retirement. Thank you.